Hello, so today we're going to be looking at the features of a deed. Of course, a deed is one of the most important drafts you'll be doing in property law practice, and is that instrument by which you can convey legal interest in property from one party to another party. So the first feature we have is the signature of the parties. Now, by the signature of the parties, it means that the parties executing the deed must sign. And of course, you know that based on the Evidence Act, if a document is not signed, then it's not binding on those parties who are a party to that transaction. So it must be signed and by the parties executing. Now, one very important precaution that must be taken in executing a deed and signing a deed is that if a party to the transaction is an illiterate, and by illiterate we mean a person who does not understand English language, then very importantly, the deed must contain what we call an illiterate jurat. All right, an illiterate jurat is simply that statement that's included, which would basically state that the person, that the content of the deed was read to the person in that language that they understand before they fixed their signature to the document. Now, if that's not contained in the deed, you see that the execution of that deed would be invalid. All right, same rule applies when you have a blind person as a party in the transaction. A blind person jurat must be included, which would again be a statement stating that it was read aloud to that blind person before they signed it. A jurat is one thing that you unavoidably would be drafting in any property law practice exam. So it's very important to know how to draft a jurat. Now, the second feature of a deed we have is sealing, which means that the deed must be sealed. Now, this sealing basically is the affixing of a red wafer on the document. It's somewhat an ancient requirement, and so it's not very necessary today. When you read section 159 of the Evidence Act, you see that even if a document was not sealed, if it was executed properly and attested properly, then there's a presumption that it was sealed. And so the requirement of sealing is something that you would usually only find with companies today. When companies are executing a deed, they would usually affix to the deed their company seal, and it will be witnessed by a director and secretary of the company, or by two directors of that company. Now, the next feature of a deed is delivery. And when we talk about delivery, this does not signify physical delivery. It doesn't mean that a person is in possession of the deed for it to be delivered. All right, delivery signifies a passing of an interest. So at the point at which one party conveys his legal interest to the other party, delivery has taken place. And of course, deliveries are two kinds. We have absolute delivery and conditional delivery. And when we talk about absolute delivery, this is where after delivery is done, there is nothing else that needs to be done for it to be completed, while conditional delivery is when delivery is premised on the fulfillment of a condition precedent or the happening of an event. And another expression we use in referring to conditional delivery is delivery in escrow. Okay, now a very good example of delivery in escrow or conditional delivery is, of course, when you are in any transaction which involves the conveyance of legal interest in Nigeria. Now you would know that based on the provisions of the Land Use Act, the consent of the governor must be obtained for that transaction to be completed, for it to be a valid transaction. So you see that even when the parties have concluded, where I have agreed and we've executed a deed conveying my interest to you, delivery is not complete yet. Why? Because the consent of the governor is not yet obtained. And so until we've applied and obtained governor's consent, and that is conditional delivery, it's delivery in escrow. Now, but does that mean that the transaction is not binding on the parties until governor's consent is obtained? The answer is no. As a result of the doctrine of relation back, you see that the deed, the transaction becomes binding on the parties from the time that they execute, from the time that delivery takes place between the parties, and not from when the condition, that's governor's consent, is granted. All right, because the deed dates back to the time that it was delivered in escrow. All right, so the transaction is binding on the parties even before governor's consent is granted. And then a deed must also be duly attested to. By attestation, we mean that there must be witnesses to witness the execution of the deed. For corporate bodies, for companies, the witnesses would usually be two directors from the company or a director and secretary of the company. And finally, the last feature of the deed is franking. Franking is basically where you have the lawyer who drafted that deed provide his particulars, his name, his address, the name of his firm, usually at the bottom of that deed. So these are the different features of a deed. And I hope you've enjoyed learning it. I'll see you another time.